Okay, so what I might do just before you do start your screen, I'll just share screen our splash screen, and then we can go to yours. So this is LAWS 13013, Legal Professional Conduct. This is week 4, and we have a guest speaker, Adjunct Professor Stafford Shepherd from the Queensland Law Society, who's going to speak to us about shaping the client journey. All right, Stafford, you can do your screen share, and we're right. Thanks very much.
Does everyone see the screen at the present moment?
Yes.
Great. Please note that there are no words on the slides. They are merely pictures. Because what I would like to do is have a conversation with you about what I refer to as shaping the client journey. Before I begin, I would, however, wish to acknowledge the Turrbal and Jagera peoples as the original custodians of the land upon which I am making this presentation. I tender that acknowledgement to all First Nations custodians throughout the state of Queensland, or wherever you may be hearing this. I also acknowledge their law women, law men, elders past, present, and emerging, for their practical wisdom and sound guidance, and for the custodianship that they have bestowed on this beautiful country and island continent of ours. What I will be talking to you this evening about, and I encourage you to ask questions and to unmute yourself to ask that question, is a little bit about the fundamentals of our ethical duties as encapsulated by rules 3 to 6 of the Australian Solicitors Conduct Rules of 2012. But then in more detail, what I refer to as the 8 C's, which I think are vital in the way in which we deal with clients. Now, many of these concepts you will have already spoken about or will speak about in your professional conduct unit. But the 8 C's for me are: 1, clearly identifying the client, because by doing that, we actually begin the road to being able to answer the questions the client wants, and also any ethical issues that may arise during the course of that journey. The second is concerned with competence. That's our ability to practice law, which has a number of sub-features. Thirdly, the client's best interest. What do we mean by that in shaping the retainer and the journey? The need for what I call a communications plan between us and the client. Civility and courtesy, confidentiality, client conflict management, and finally, closure, that is, bringing the journey to an end. And by the journey, I mean the retainer. Now, in the Australian Solicitors Conduct Rules, you won't actually see the word retainer. What you'll see is the word engagement. But the retainer, of course, is a contract between us and the client to deliver legal services to the client. That contract can be widely and variable these days. So increasingly, we've seen solicitors particularly undertaking discrete legal service delivery, where they are only doing part of what was originally their whole function. And in this regard, I'm thinking about essentially litigation, where when I started in practice, my responsibilities began with the letter of demand right through to the conclusion of either a settlement or a receipt of judgment from a court and its subsequent enforcement if necessary. But these days, solicitors are moving in and out of matters. They may be, for instance, involved in only the preparation of the proofs of evidence or the affidavit material that is desired by a client, and then will exit. So that's a discrete legal service, but still is a retainer. And retainers need not be formal. So you've been talking probably about the obligations of disclosure and cost agreements, which are prescribed by the Legal Profession Act in this state. Now, they're statutory requirements, but the retainer has existed at common law and can arise even if there is no payment to be made between a client and a practitioner. So in shaping that client journey, we first of all must clearly identify who the client will be. And that client is the person to whom our essential obligations are owed. This slide, however, is about something more than just the client. The fundamental ethical duties that I referred to at the beginning are rules 3 through to 6 of the Australian Solicitors' Conduct Rules. You'll probably have spoken about those rules in discrete subjects that you've been talking about. I want to group them together, and they are, in my mind, the pinpoint through which the refraction and rainbow is cast in the prism. Because I take the fundamental ethical duties as the foundation for all other duties that exist under the Australian Solicitors' Conduct Rules. And the rest are mere parts of those rainbows and inform and enliven and are given substance by the fundamental duties. So the fundamental duties are rules 3 to 6. Rule 3 is a very simple rule. The best rules in the ASCR, if I can put it this way, are the truly simply constructed rules. The rule 3 essentially says that our first and paramount obligation is to the courts and the administration of justice. That rule trumps all other rules that may exist within the ASCR and is a reflection of the common law principle that we are officers of the court. As you probably appreciate from your study as well, you will seek and apply for admission, and you will need to establish or obtain a certificate of fitness. But the admission ceremony is important in two regards. You'll be asked to take either an oath or affirmation to two different parts of our democratic system. One to the Crown, which is currently represented by King Charles III, and the second to the administration of justice as well. So that fundamental duty in 2012 was reshaped to include the words and the administration of justice, because we wanted practitioners to appreciate that whether you're acting as an advocate in a courtroom or as a trusted advisor in the privacy of the conference room, or as a negotiator with another practitioner or a third party, or as a conciliator, or as an agent, the obligation to act in the administration of justice is the first obligation. Rule 4 then sets out what are referred to as the other fundamental ethical duties, and they comprise, and we will talk about them in detail on the journey. The first is to act in the best interest of the client. Now, you've met that concept before in your studies, because you would have met it when you were studying fiduciary obligations in equity. The essence of an obligation is one of trust and confidence. And of course, we are status fiduciaries as solicitors. I speak essentially as a solicitor. I've been a solicitor for well over 35 years these days, and I can only speak for that level of the branch. But there are equivalent obligations appearing in the bar rules. We should also remember, for sake of completeness, that the ASCR is not a piece of subordinate legislation. The notice which creates the ASCR is the ASCR, however, is not a code, nor does it modify the common law. A breach of the rules can, of course, sound in unsatisfactory professional conduct or professional misconduct. But what we should appreciate is that there are two aspects of ethical decision-making. The intrinsic, that is your own moral compass informed by your own ethical, religious, and societal background, and then the extrinsic, which are the Legal Profession Act, the regulations, and the respective rules that were created by the professional bodies. We then have competence, which I'll speak about shortly as well. We have an obligation to be honest and courteous in the way in which we deal with not only other practitioners, but with members of our own staff and with the agencies that we're involved with. We have this obligation to retain our integrity and professional independence. And as I speak with many solicitors over in the state of Queensland, one of the things that we need to remember is that the courts rely on our degree of impartiality and our degree of separateness from the client. In the High Court, in a decision called Bell Lawyers, which examined whether the Chockley exception, that was an entitlement when we were self-representing before the courts to charge for our professional services in labour, should still exist. And the High Court, in very clear words, said that the modern orthodoxy was against that. What they rely upon is us as their officers to impartially and accurately bring to the court the law and the facts. We should do so robustly for a client, but we're there as the assistants to the administration of justice. We're not the people who administer justice itself. We have an obligation to maintain a respect and a understanding of the law and the rules. It doesn't mean, of course, that we can not criticize the rule or alternatively the law itself. But we should be mindful that we, as those officers, are required to comply with them. Justice Casasio, a justice of the New York Courts of Appeal, once said of attorneys, similarly for solicitors, we choose to walk a higher plane. And that is because, as Tim Dare, a legal advocate in New Zealand, would say, we choose to place upon ourselves a new cloak. Now, I sometimes think that Tim, when he talks about the many cloaks, is really talking about a similar concept that Joseph had. Joseph had, if you know your biblical stories, a coat of many colors. We have a cloak of many colors ourselves. We're on occasions an advisor to the client. Sometimes we act as their agent. Other times we act as their advocate. We hope we act as their trusted friend and advisor as well, and a conciliator. And those various positions we adopt depend upon what we're doing for a client at any one time. We then have the obligation, which is replicated in your admission, to remain fit and proper. So very soon I'm applying for a renewal of my license to practice. We call that the practice certificate. I have an obligation, a positive obligation, to disclose suitability issues to my professional body, the regulator in this case. But it goes a lot further in Rule 5. It also talks about that we shouldn't be doing any action that will be prejudicial to the administration of justice or to bring the professional into this review. And finally, Rule 6 sits by itself, but it's an important rule. It's a rule that says that if I make a promise in the course of legal practice, I'm to honour that promise. It's referred to as an undertaking. The word undertaking need not necessarily be used. If it is a promise to do or forbear from doing something given in the course of legal practice, whether it's to the client or a third party or a colleague or to the court, then we have to honour it. We can be, of course, released from an undertaking once we have completed whatever our promise was, or if the recipient is prepared to release us, or alternatively, for the competent jurisdiction. Young practitioners, I urge not to give undertakings lightly. Any undertaking should be properly recorded and should be precise and clear in the manner in which it's addressing whatever the promise may be. If you need to look at a case about a solicitor who forgot about an undertaking, then look at the decision of the Legal Services Commission and Lightway Legal. It's exceptionally important to understand how much the courts rely on us when we give our promise to do or forbear from doing something. So if you understand those fundamental ethical duties, which are prescribed in a single chapter within the Australian Solicitor's Rules, Rules 3 to 6, that pinpoint for which all other rules are refracted, I think you have a really good understanding of what we have to do, both in helping our client on their journey, the resolution of their legal issues, and secondly, and ensuring that we don't fall on the wrong side of our disciplinary process. So the first issue I want to do is clearly identifying who your client is. This is so fundamental to many of the questions I ask of practitioners. And it needs to be clearly identified in your retainer as well. So you should be asking yourself, do I act on behalf of an attorney, or am I acting on behalf of the principal? Because if I'm acting for the attorney, my role is to advise the attorney with respect to the course of action they should be adopting for the principal, but reminding the attorney of their fiduciary and statutory obligations as relating to their beneficiary. If I'm acting for a company, do I have the appropriate authority to act for that company? Because although companies do their work through human agency, we need to be certain as to the authority. So there's a decision out of the Australian Capital Territory called Doulman, D-O-U-L-M-A-N. It's now around about 10 or 12 years since it was released, but it's a salutary reminder to practitioners. The solicitor in that case had been taking instructions from what was a former solicitor, and that solicitor believed that that person was authorized by the company to act. What he didn't do was a simple asset search to determine the directives. If he had done that, he would have realized the person sitting before him and purporting to give instructions to the company didn't have any ability to do so. The matters that he worked on behalf of the company were taken to a point where orders were being made in the federal court for sequestration. When it was found out that there was no authority for the solicitor to have commenced proceedings, he was successfully sued for warrant of breach of authority to act. So simple task, identifying if I'm acting for mum and dad. And that could be as simple with a conveyance. Then who is authorized? Do both speak? Do one speak? The retainer needs to be shaped to deal with those issues of authority and communications. If I'm acting from a mum and a dad in an estate plan, it is necessary to ensure that we modify the implied duty of confidentiality, because only through an open dialogue between all can we avoid having potential conflict. If, however, we don't, then there are duties of confidence which may arise, which means that we create a conflict in the process of continuing to act for one or more of the people involved in the matter. Sometimes we need to make certain that when we're acting for a trust, we're not just acting for the trustee. Are we acting in reality for a beneficiary? I get a lot of questions about this in estate work because executors may be both the personal representative and the beneficiary under the estate. Is the solicitor acting for the personal representative, or is the solicitor acting for the beneficiary in that context? And could they have a conflict purporting to act in different capacities at different times? So understanding the client, and in particular some of the attributes that clients can bring to our relationship with them, is important because it can shape the contract. It can be modifying the obligation of confidence. It can modify, but not exclude, in my view, the duty of loyalty. It can ensure that we're shaping what we're doing on behalf of the client, so we know what is to be done, what we won't be doing the expectations of the client, our expectations that may be received from them, that they will be honest and forthright with us, and that should be an express term within the retainer. So some of the attributes that I have seen troubling solicitors, and troubling them in a way that somehow causes the retainer to go off the course of road that they have adopted, is, for instance, one may be that the solicitor has not made a thorough investigation as to why the client is seeing. So, for instance, if clients shop about for their legal advice, they're certainly capable of doing that. No problems at all. But our knowledge of that is important in how we address the issues of dealing with the client itself. We should find out why they were dissatisfied with the prior work undertaken by another solicitor. What was the opinions being expressed by that solicitor? Was the client a slow payer? Are we, by accepting that client, inheriting the very legal consequences that that client is trying to avoid? Are there any liability issues for us? We need to ask those questions right at the beginning to avoid the potential for us to become undone and stuck in a matter. All clients are concerned by costs because it is one of the central issues that is the form of complaints to the Legal Services Commission. Now, you probably appreciate the Legal Services Commission is responsible for the investigation of conduct matters with respect to solicitors. The Society has powers dealing with conditions and impositions on practicing certificates and has a role in auditing a solicitor's trust account. We should also appreciate, even if the solicitors, which is a modern activity, don't have a trust account, the audit process continues to exist because under the Act, the Society, through its investigators, has the power to make certain that funds are being paid or should be being paid into a trust account. And that may require an examination of client records. And as I said, you'll have talked about disclosure, which is under 380 and 381 and 382 and 315 and 316 and a variety of other sections of the legislation itself. But what I'm talking about in costs is where a client wishes not to undertake work which you believe is necessary for you to provide an opinion to them. So we have solicitors who tell us that their clients don't want them to do title searches or to do company searches or to examine an easement document. And it could potentially be possible to shape the retainer to exclude and to remove that from it. But if you don't have those discussions early on, then the heartache caused by not understanding the client's desire or obsession to maintain a control of costs may lead to error by the solicitor too. We sometimes have clients who have formed great expectations. They've already formed in their own mind the outcome to which they want to reach. And again, it's about managing that. It's about having a discussion early on in the piece with the client and being able to indicate that there is a demarcation between the client and us. So under Rule 8, again, a very simple rule. We are required to follow the lawful, proper, and competent instructions of the client. And that's right. But the way we execute it, the way we undertake it, is for us. That's within our autonomy. So the High Court emphasised that again in Bell Lawyers by reference to Rule 17, noting that solicitors are not mere mouthpieces of clients, that they must exercise forensic judgment in the way they undertake the work on behalf of our client. And that should also be placed in the retainer, a clear indication that we have to exercise professional independence, that we are not merely there as a servant to undertake anything they tell us. We have certain constrictions upon us, And they do too. We have a obligation to maintain our own autonomy as well. One of the dangerous clients is the 11th hour client. They're the ones who come to you at the stroke of midnight, requiring you to do everything under the sun. And again, this concept of cost is needing to be discussed with them. We have to look at time, quality, and cost. And then we have to ask ourselves, do I have the time to undertake that work? Will they pay me for the work? Because if the client doesn't understand the scope of what is required to be done and the time constraints that are being imposed, they are normally likely to have and be upset with the practitioner. Sometimes a client who I refer to as a missionary, they don't have anything apart from the belief that they know what the ultimate victory will look like. And they will do so supposedly at any cost. But it's again controlling their expectations, which are important in our relationship. We sometimes have an unstable client. And again, there's nothing preventing us. None of these attributes I'm talking about mean you shouldn't have. What I want solicitors and practitioners to be aware of, and what you should be aware of, is how we can use the retainer to better deliver the services, understanding what those attributes may be. So a client whose behavior becomes questionable or erratic, we've got to understand that competency, their ability to give instructions, may fluctuate. And how do we deal with those issues as well? We have clients who have little helpers sitting on their shoulder who whisper into their ear, but I received the 50,000, why aren't you? And so we have to have a conversation, which may be difficult with the client, to ensure that they understand that how allowing others to whisper in their ear will not be of benefit to them. Sometimes we should know that clients like to sue us. That's again fine. There may be good reason for clients to do so, but we have to understand if they're coming to us at a very late stage, having had 2 or 3 solicitors beforehand, that they're likely to bring action against us as well. How do we deal with that and shape the retainer to reflect that? Finally, we consider the most dangerous of clients is to be your nearest and dearest, because unfortunately, we may lack the necessary degree of impartiality when dealing with them, or we take the view the matter is so simple it can be dealt with in any manner that we choose. It's normally in those circumstances when I speak to the solicitor that they've dug an enormous hole for themselves already. So getting to know the client and identifying them and identifying their attributes is the first of those C's. The second is our own level of competence. Now, we know competence being the discipline of what you've been studying over the last few years. Understanding contract, tort, equity, succession, vendor and purchaser, whatever it may be. But it also means that we have to be thoroughly prepared, not only for the advocacy within a courtroom, not only for the negotiations for the contract, but even in the quietness of the conference room between us and the client themselves. And underlying that is a competency in the use of technology. Increasingly since COVID, practitioners are using video conferencing as a means to communicate with their client. We have to ensure that the communications channels are appropriately protected. If we're sending documents via the internet, do we have a means to protect the document from interception? Are we encrypting it? Are we actually even, for inadvertent disclosure purposes, washing a document of metadata to ensure that documents and breaches of confidentiality with client legal privilege don't occur? In addition to that, we have an obligation to look after our own health and well-being, because what I know from reading the reports over many years now on disciplinary cases, as well as speaking with practitioners, if their health and their well-being and their resilience is low, that is more likely to lead to charges of unsatisfactory professional conduct. So keeping that balance between client and our own welfare is important for you to have regard to as well. We have an obligation to ensure that we act in the best interest of the client. Now, when I talk about best interest, I'm really talking about the concept of loyalty, and it has a number of features in our responsibility. One is to maintain the confidences that are imposed on us by a client. Two, we're to avoid conflicts, which are dealing with former clients that have as its essence the protection of confidential information. So, for instance, Rule 10 will provide the only two bases upon which we in the state of Queensland can act against a former client. And that is one, when we don't have confidential information, or if we do, the client has given us informed written consent, or alternatively, we have an appropriate and effective information barrier in place. There are loyalty issues when we're proposing to act with two or more clients in the same or related matter. And why that becomes important is that we know for Inspector's case that when we come to a client retainer, we must bring to the client all our material knowledge and skill wherever we had sourced that knowledge from. A good case to read about this problem of acting for two or more clients and about how the retainer actually assisted the client in that case is a decision from the House of Lords in Hilton, Barker Booth Eastwood, around about 2005. What essentially occurred in that case is that we have a rogue who had been using a firm of solicitors to enter the plea of guilty, served a term of imprisonment, and was no longer entitled to hold corporate office. On release from prison, he saw an ad that encouraged an approach to a client or to another person. This was to develop a block of land. They both used the legal firm, and they both went to that legal firm. Now, in the term of the retainer, there was a contractual obligation to act in the best interest of the client. Remember that best interest requires that we as practitioners bring all necessary skill and knowledge to the service of the client. What the firm couldn't do was disclose information concerning the past activity of one of those clients, the rogue, the person who had been found guilty of fraud, but never raised it. And as the House of Lords pointed out, it wasn't a contest between the contractual obligation of confidence and the equitable obligation of confidence. It was actually a battle between the duties of loyalty. And the solicitors had failed to correctly identify who their clients were and their obligation of loyalty to both. And as the House said, it falls upon the solicitor to work that out, and in failing to do so, have breached their fiduciary duty, in this case to Mr. Hilton, and the House ordered that the trial judge assess the compensation that was to be paid, the damages, because what occurred was the breach. The breach was a breach of the retainer, not of the fiduciary obligation. The fiduciary obligation is certainly overlaid it, and it's not unusual to see in retainers the obligation that you will act in the best interest of the client. In failing to act in the best interest of the client, we also sometimes need to reflect that information we obtain from client A, even if it's not in the same or related matter, may be of benefit to client B. And therefore we need to control what the retainer says. If the retainer is silent about that, and it has not been brought to the attention of the clients, there could be a failure in the duty of loyalty to one or both of them, even though it's not in the same or related matter. Because as I say to you, Spector's case says we must bring to a client relationship all necessary skill and knowledge wherever we may have secured it from. And so we need to clearly work out in our retainers how we manage those potential expectations and issues of loyalty. We also should be reflective of the fact that in this very important aspect of serving the client's best interest is the need on occasions to modify the duty of confidentiality. Because if we're proposing to act for two or more clients in the same related matter, as I've said previously, we need to shape it to allow a full disclosure between the parties. Otherwise, we could potentially create an issue. And finally, we can't allow our own personal interests to override that of the client's. And that can occur where a solicitor has, unfortunately, fallen into error, and where they're where they're trying to dig the client and themselves out of that error. And there are many occasions where I've had to advise solicitors that they'll need to terminate their retainer, inform their insurer, and hopefully move on. When we think about that relationship, we also need to think about the journey as being not just us and the client separately, but we are together. And as this picture tries to identify, we need to assist each other. And a communications plan is the best way to do that. So, for instance, many family law practitioners say they are inundated with emails or texts from their clients. What needs to be done is right at the beginning of the relationship, we set out a plan to indicate when we intend to communicate. I was speaking to a large global law firm recently, and they've adopted the habit, even if it's only 2 minutes, to speak directly by video conferencing in a secured manner with the client. Telephoning a client is important as well. It keeps them informed and attached to us. Written communications is important, whether it's to be by the email or letter, and how regularly that will occur. And if a client is demanding, to clearly set out right at the beginning how we're going to respond. Because the Legal Services Commission has noted in its reports that 3 major issues that are confronting the profession are communications, costs, and conflicts. And we can always manage the expectations of a client. There will be occasions when it is impossible to manage a conflict, and we have to leave. We have to terminate our relationship with the client. But a clear communication strategy, developing how we're going to deal with it, how we're going to deal with the email, the text, the telephone calls, and adopting the approaches such as by telephone or letter or a good email is a good way. Can I also say that I had a very good colleague in New York during COVID, and they noted too that in the COVID lockdown in New York City, one of the problems that arose was the fact that solicitors or attorneys in those jurisdictions may not have had sufficient work. So they began to share work from other firms amongst themselves. They shouldn't forget that, unfortunately, that sharing is a breach of the confidence and retainer between respective clients. It also means that privilege may be lost in those circumstances. The other thing that became evident is that many of the modern attorneys loved Google Home and Siri and Alexa, and that was sitting at the background listening to all these conversations that were taking place as well. So the duty to act in the best interest of the client means that we competently understand technology and that we competently are able to create an appropriate means to communicate with the client itself. Civility and courtesy. So can I say this? Around about 6 to 7 years ago, Justice Philip McMurdo, as he was then, spoke to our symposium, and he indicated that the best way to secure your client's interest was to ignore the ill statements and discourteous behavior of your opponent and to get to the real point. He said civility actually increases the ability, 1, to retain a client, 2, to get your work done, 3, not to be distracted by anything that's external to that retainer, including the misbehavior of our colleagues. There may be appropriate means to deal with that by, if need be, complaints to the commission. But keep getting on with the job. Don't be distracted. I've recently read letters where 3 to 4 pages of it are taken up not by the client's issue, but by the behavior between the practitioners themselves. And that level of courtesy, I should indicate to you, is not just to our client and not just to our colleagues. It's to your fellow workers within your legal practice and to all those who work for government agencies as well. We do hear on occasion through the society how there have been misbehavior or discourteous behavior or incivility directed to court staff. And that doesn't help you at all. I can say that quite clearly. So one of the underlying concepts that we have is, of course, confidentiality. Now, confidentiality is implied in all solicitors' retainers, unless otherwise modified by an express provision in the contract of service as well. So generally, any information we obtain during the course of our client retainer will be confidential, unless the client has given us permission, express or implied, to utilize that information. Now, Rule 10 encapsulates the rule of confidentiality. We can, of course, share confidential information internally within our own legal practices or where we wish to engage third parties such as a barrister or an expert. But the main permitted exceptions to confidentiality appear in what is called Rule 9.2. Now, 9.2 covers a variety of aspects, express and implicit disclosure. And I say prudent practitioners will always reduce to writing any implicit instructions they feel that they may have, so that it is properly documented in their file. The second one is, of course, where we are permitted or compelled by law. Now, under the Powers of Attorney Act, the statute actually abrogates confidentiality and client legal privilege where the power has become active and the attorney is seeking information from the principal's former practitioner solicitor in the matter. We know that increasingly the government, in a variety of pieces of legislation, are abrogating confidentiality. And we know that in recent times that they've done so with respect to child abuse matters. What I do caution all practitioners to do in those circumstances is to read the statute carefully, determine whether confidentiality has been abrogated, then determine whether client legal privilege, legal professional privilege has been abrogated. And if it has, then only disclose that extent which is reasonably necessary to comply with the statutory expression. Now, in Australia, or in Queensland, at least at this present moment, we don't have extensive statutory requirements in anti-money laundering. That may change within the next 12 months to 2 years. What we do know is our counterparts in other jurisdictions are faced with what are called suspicious transaction reporting, which causes quite a significant difficulty for those practitioners. And so we have to be wary of and cognizant of changes in legislation as it deals with us. We, of course, are entitled to seek confidential guidance and assistance from our professional bodies, from QS senior counsellors, or at the bar, the appropriate ethics officers designated by the Queensland Bar Association. And that is replicated to common law. Common law has always provided that we can seek that sort of guidance and support. To explain partly our service, I've been with the Society 15 years. Any communications with us these days is through the QS Ethics and Practice Centre, which is a business name for QS Solicitors Support Proprietary, which is an incorporated legal practice owned by the Society, and it's dedicated to providing guidance, support, and necessary assistance when a practitioner is seeking views with regards to the way in which they should approach an ethical issue. I do indicate to you we are not substituted decision makers. We will provide the necessary guidance. Now, that guidance on many occasions is now recorded. It's protected. It's not able to be seen by the society. And you can utilize that for the purposes of supporting any course of action you adopted in the course of your practice. We should inform you that, of course, the Legal Practice Tribunal, the QCAT Tribunal, Legal Practice Committee, the Executive Committee of Counsel are not bound by that guidance, but may assist them in knowing why you undertook the steps you did. Now, confidentiality also has a permitted exception where it is a decision where you are facing a situation where you are trying to prevent the commission of a serious criminal offence. Prospective, not past. And so there are occasions where you have concerns that the client may be involved in serious criminal offences that may be prevented if you make disclosure. We've spoken to practitioners about that, particularly in the terrorism area. What we do need to understand is it deals with future actions, not past actions. If a client confesses to you, and they confess to you by telling you about an offence that they've committed, then of course they have the protection of the confidentiality and potentially privilege in that relationship as well. Now, we also have a permitted exception where we are aimed at preventing the imminent serious physical harm to a client or third party. Now, when I first started with the society, a lot of that dealt with family and criminal matters. Today, it's very widespread. We have seen solicitors concerned about whether a client could undertake self-harm in litigation unconnected to the criminal area as well. But remember, it has to be imminent serious physical harm. And finally, there is an occasion when you may have to make a disclosure to your insurer, and that's also protected under the rules themselves. There are three styles of significant conflict that you need to be aware of. Rule 10, which is concerned with former client conflict, and the protection is confidential information. The second is Rule 11, which is currently drafted and has been in our operation since 2012. I should point out that other states, particularly in this case Victoria, New South Wales and Western Australia, have recently adopted changes to the Australian Civil Conduct Rule, which do make alterations to Rules 10, 11 and 12. But for our purposes, our rules still remain in place. The big difference between solicitors in the uniform states, again, that's New South Wales, Victoria, and Western Australia, and us, is one, they don't need written informed consent by a former client. They can rely on informed consent. We still require the written informed consent. The big difference too is Rule 11, which is concerned with concurrent conflicts. Now, I just say to you that Rule 11, where if you read Rule 11, and it goes for a number of sub rules, and it's a long rule, and it doesn't sit happily with my concept that the best rules are the most simple worded rules. If you read it, in essence, it is just about loyalty. Just about loyalty. If you can identify and manage the loyalty aspects in your retainer, you're best to do so. And Rule 12 is all about personal interest conflict as well. We do need to bring the relationship to an end. Now, most modern retainers will have lists of express entitlements to them. Trust and confidence is an enormous issue. There is a decision of the Court of Appeal in Stark and Dennett, and I think if my memory it's about 2008 or 2012. In Stark and Dennett, what occurred is this: at trial, the late Justice Douglas determined in favour of the solicitor. He said the solicitor was correct in not providing client documents when he had an effective lien. The Court of Appeal, however, through the leading judgment of then Justice Keane, who eventually goes to the High Court, is the judgment to read. As Zion pointed out, it is surprising that on occasions we have clients who are ungrateful and difficult. But it's the obligation of the solicitor to bring to the attention of the client if they're expressing a lack of trust and confidence, and to clearly indicate that they want the solicitor to continue in the matter. But if they continue to manifest a lack of trust and confidence in their behaviour, then the solicitor should notify them that they intend to terminate the retainer and provide it on reasonable notice. If you have a look at Rule 13 of the Australian Solicitors' Conduct Rules, it really replicates the common law entitlements. So, for instance, mutual discharge is a means by which we can bring a retainer to an end between a client and solicitor. A client can terminate a retainer without the need to provide reason to do so. We can do so for just cause and reasonable notice, and Stark and Dennett is a good reflection of the application of those principles, as well as is operation of law. Death of the practitioner can bring about the end of the retainer as well. When bringing about the end of the retainer, we in the state of Queensland bring about an end to the duty of loyalty. Now, we don't end the duty of confidentiality, but what we do is end the duty of loyalty. Now, that is important because if the duty of loyalty continues, we may have continuing obligations to inform a client of changes, for instance, in estate plan law, because there have been a number of successful suits in the United States against attorneys who don't bring the client relationship to an end. I would have one caveat to what I'm saying, and in the state of Victoria, there is a decision called Spin Code. Now, Spin Code has been interpreted in state law that the duty of loyalty continues post the retainer. Now, federal courts have a different view. Other jurisdictions, such as Queensland, also take the view that loyalty comes to an end. But just remember that in Victoria, when we're dealing with Victorian practitioners, there are some further issues. We do have a wide supervisory ground where the court can grant an injunction where it is in the interest of justice to do so. They won't do so lightly. And that's not a ground based on confidence or loyalty. It's based on the control of the court's own officers. So bringing that closure about is important to ensure that we and the client know that we are bringing a matter to an end. So in these last few minutes, I'm happy to take questions if you have any. I just want to also mention the words of Lady Hale. Lady Hale is a former president of the Supreme Court of the United Kingdom. She mentioned that there are 3 levels of courage for us as practitioners. The first is the courage to be aware of what we can't do. Ask questions, seek assistance if you can't do it, but tell the client if you can't do it, because it may be better for you not to be doing it on behalf of the client at that stage. And they, don't worry, we'll come back to you. The second is if we do have the skills, the competency, and the time to do it as to the best of our ability, to have that courage. But the final courage is the courage to say a simple word: no. No to bad behaviour by a client, no to bad behaviour by a colleague, no to bad behaviour if it's within the court itself. That is a difficult word, Lady Hale said, but is an important word in the vocabulary. So I'm going to summarise for you what I hope I've expressed during the course of this discussion. That the client journey can be shaped by you, the practitioner. It can be shaped successfully if we take the time to engage with the client when we initially meet the client or when they come back to us. We have to ask ourselves constantly, do I need to shape confidentiality? Do I need to shape the duty of loyalty? Do I need to deal with any of those attributes that I mentioned to you? If you do that, then that journey we are taking with the client to give the client the outcome and expectation and value they want can be successful. What does occur, unfortunately, is that there's sometimes a failure by us because of time constraints or because of our inability to first understand what those instructions are that lead us to diverge paths and sometimes have disciplinary issues. If you need to contact us, certainly we're available. We are a member-based service of the Queensland Law Society, so membership is a requirement, although I have a discretion to speak to students and to others as well. I end with saying this, if I may. Sir Gerard Brennan mentioned two things in the past. That is the late Sir Gerard Brennan. One, that ethics cannot be reduced to a set of rules, and to do so will only lead to spiritless compliance or scribble and beg. And secondly, as he mentioned in Pillars of the Profession, the mundane acts we do, preparing a contract, guiding a client through the difficulty of buying their first home, helping them prepare their will and estate plan. They may seem mundane, but in doing so, you are serving the rule of law. So I wish you all very well. Thanks, Stephen, for the opportunity to speak with you. I look forward at some stage to being able to meet you in person and to speak with you once you've entered the profession. Remember, the day that you seek admission will be a wonderful day for you. I sometimes tell students that Harry Potter sprinkles magic dust upon you because you're transferred from a normal citizen into somebody else. Thank you.
Thank you, Shepherd. Are there any questions from our students here this evening? Anybody got any question for?
Did you invite us to get in touch with you if we have some kind of ethical challenging moment with clients in the future?
If you're a member of the society, you certainly can. I speak to students mainly about their admission issues. But if you're a member of the society, you certainly can at any stage.
This is in reference to once you're in practice.
Sorry?
This is in reference to when you're in practice.
When you're in practice, if you're a member of the Queensland Law Society, we are a free advisory, counselling, guidance service to you.
All right. Other questions? No, I have one question.
Yes.
For Stephen, and that's in relation to generative artificial intelligence. If we get to the stage where legal services are being offered based on output of generative artificial intelligence, how is that going to sit with the sorts of arguments and the presentation you've been giving tonight?
Well, first of all, the question will be whether the Act is modified to permit artificial general intelligence to deliver legal services. Certainly, solicitors have in their armory the ability to use various forms of technology already to assist them. The difficulty is what we're meaning by this idea of artificial general intelligence. I've just completed reading a book, and I was speaking to students today about it. And it's called What We Owe the Future by William Maskell. And in that book, he asks us, just like has been the recent discussion, that we may need to just put a brake on it for the moment, because we've got to decide what we want out of artificial general intelligence. If you're asking me, Stephen, whether the role of the solicitor will go, I don't think so. I don't think so. Not at this stage.
It's an interesting question because the pace of the development of these types of intelligence is quite rapid.
Yes.
And these services may well come from outside of the jurisdiction of Queensland.
Yep.
And
It's-
the ability to police and regulate them may be very limited.
Absolutely. Yeah, ready. I am aware that there are proposed services emanating out of South America, which will be competitive. It's a question of education of the community. I think we need a broader education of the community about what services we as practitioners do offer them and what are unauthorized legal practitioners. So, for instance, and I appreciate it had nothing to do with artificial intelligence, the Commissioner has in the last few days obtained an injunction to restrain a non-legal person from delivering legal services within the Gladstone area.
It's an interesting question. Look, at this point, I'd just like to, on behalf of everybody, to thank Professor Shepherd for really traversing the whole course, if I can put it that way, because quite a number of these areas you haven't got to yet, but you will be coming to. So I think it's a very useful presentation that you've received because it gives you an overview of the whole area, and I'd just like us to show our appreciation in the usual way. So I'd like to thank Stafford. So thank you.
Appreciate it.
Thank you, Stafford, on behalf.
Thank you.
All right. We might ask you to stop sharing, Stafford, and then I'll just make a couple of comments about some course matters. All right. Thank you very much. Just to let people know that the week 4 tutorial questions, I've actually put up some answers to those on the website so that you can access those and have a look at that. There's quite a lot of exercises there on trust accounting and work solutions. Stafford will be very happy to know that because we do actually teach the trust accounting elements at CQU. But I will be posting up some video materials. I'll make them tomorrow and post those up for you to have a look at as well. So on that note, it's 8:05, so it's time for us to leave. And I look forward to seeing you all again next week. Not you, Stafford. I'll catch up with you on another time.
All right. Thank you.
Thanks very much. Bye.
Thank you, Steve. See you.